feel that like specific characteristics don't matter as much as like as a group of jury members should be like well-rounded. You need like a little bit of everybody.
There are many differences between psychology and the law, specifically in their ideas about the ideal jury. My group and I, Maggie, Victoria, and myself, have interviewed two different people, Dr. Michael Bailey from the psychology department at the University of Charleston and attorney Edgar Hike High School, to see how opposing their views on the ideal jury really are, or if there's any difference at all. We hope you enjoy.
Dr. Bailey, what are some important characteristics that you feel jury members should have?
Well, actually, there's no such thing as an ideal juror. It depends on the case. Criminal law probably is best defined by what the Supreme Court said, which is a cross-section of the community. That's criminal law, and it probably should be a cross-section of the community, so all voices are represented. Civil law is different. Under Old English common law, a jury was actually supposed to be composed of experts on the matter in question. That still, to me, makes sense. If you're in a land dispute or a chemical dispute or whatever the case may be, doesn't it make sense that the jury should be experts in the matter so they actually know what's being discussed? To me, that makes sense, and that's what I think it should be. So it depends. Criminal law, cross-section of the community, civil law, they probably really should go back to the old system of experts.
So, do you agree with how lawyers actually go about picking jury members?
No, I mean, as we discussed in class, most lawyers attempt to load a jury with persons that are favorable to their side at best, or they settle for eliminating people that are favorable to the other side. They're really not after an unbiased jury. They're after a biased jury. They're after a jury that will favor their side, or at least won't favor the other side. And so, no, I can't say that that's necessarily a good system in operation. I don't think it is. I think it can be improved on.
Do you think there should be different jury members' qualifications whenever dealing with a capital punishment trial?
Yes and no. Again, that's a criminal matter, so cross-section of the community is probably the best choice. One of the suggestions, and I forgot who made it, I truly forgot who made it, it was probably Phoebe Ellsworth, is that jurors should be, capital cases should have actually two juries. The first jury decides guilt, and the first jury would be open to both, as we know by definition, what excludables are versus death qualified. The jury that hears the actual trial and decides guilt should be composed of both excludables and death qualified. They really should be, because the evidence is consistent, that they look at evidence differently, they deliberate differently, etc., etc. So they both need to be there. On the other hand, if the defendant's convicted, obviously excludables aren't going to vote for the death penalty. That by definition is true. So in the sentencing phase, it would be appropriate to reduce the jury to just death qualified jurors, because the fairness of the trial is determined in the first phase anyway, and the determination of guilt or innocence.
If you could, in some sort of way, if you had the authority to, would you change anything, any characteristics about jury members?
Jury selection?
Jury selection.
Probably not. I mean, I honestly have sympathy for the law in the matter of jury selection. People try to avoid jury selection. I actually think in terms of the development of the jury pool, they're doing a good job. Voter registration rules, driver's license rules, tax rules. They're trying to expand the pool as much as possible. It's not actually changing that. It's really changing lawyers' minds about what they want out of a jury, right? And what they should really want out of a jury is a jury that's going to fairly and impartially hear the facts and decide the facts, decide a case, based on the facts, as opposed to what they're doing right now, which is competing against one another during the selection process. I mean, the process itself is probably as good as it's going to get. It's the lawyers' minds that we have to change so that they're going after the right objectives and goals.
My name is Edgar High School. My nickname is Hike High School. I am a product liability lawyer with a national auto products practice based here in Charleston, West Virginia. The kind of work I do is represent victims of product defects people who are injured in automobile accidents where the vehicle is defective. The ideal juror on a case that I would have would be someone who's open-minded and who can be fair toward both sides. I'm always looking for someone who has a reasonable amount of intelligence and who can understand some of the concepts and the science that we have to rely on when we're proving a defective product. Someone who can get the concept of some engineering, and but basically just looking for someone who can be unbiased, no prejudices against either side, and who can embrace our presentation of the facts. The basic way a case works is that a victim contacts me. They've been in a runaway Ford or a runaway Toyota, and we have our engineers look at the vehicle and determine if it has a design defect. Some of the modern vehicles have so much information to process through the computer that the signals get into the computer and get confused. It's like your laptop sometimes not doing what you want it to do, and sometimes on its own saying that there's been an error. Well, it's that kind of thing that happens inside the computer of a vehicle, but it can have very, very serious and dangerous results if it is sending a signal to the throttle to go full open. And that's one of the problems with the Toyota vehicles that we're in litigation over right now out in California. We have scientists who've been able to show that the Toyota computer is easily confused and will send a signal to the engine throttle to go to full open. And as a result, people have been killed or maimed when the vehicles do this. We're trying to get Toyota to own up to the defect. Same thing with Ford products. They too have a similar defect and a vulnerability to electromagnetic interference from other things going on in the vehicle and under the hood. And you're going to see more and more of this kind of litigation in the coming months and years, because there are approximately 40 million vehicles out there that are Ford and Toyota products that have this vulnerability. So unfortunately, the companies have refused to recall the ones with the electronic defects, and so it's left up to plaintiffs' lawyers like me to hold them accountable. The government has abandoned its watchdog role and has basically been in bed with the industry, and therefore has not exercised proper safety regulations against Toyota and Ford. And as a result, millions of vehicles that should have been recalled for a safety defect are still being driven by American families without any warning from the manufacturer or from the government. And so again, it's up to the courts and to the plaintiffs' lawyers to hold the companies accountable. And that's what I do. As far as people that we need to present our cases to, again, all we ask for is a fair and impartial jury, and we meet the burden of proof in our cases. And if people are properly open-minded and not biased or prejudiced by Rush Limbaugh or Glenn Beck or some conservative talk show, we think we will get a fair-minded jury, and that's all we seek.